Hey everyone, welcome to another edition of The Bullet. My name is Paul Lathrop. I'm the Deputy Director of New Media for the Second Amendment Foundation. Joining me today from the Ooley Law Offices and the O2 Gun Group, Alex Ooley. Alex is both an attorney and a firearms trainer, so he's one of the good attorneys. Alex, thanks for coming along for the ride today, man.
No problem. Great to be with you, Paul.
Couple things to get started today. Well, first of all, I should mention, as we do every time you're on, nothing we're about to say is legal advice. Although Alex is an attorney, he of course cannot give legal advice to anybody who's not a client, and certainly not anybody outside of the jurisdictions he covers. So, if you need legal advice, get an advice from an attorney in your area. This show is for entertainment and education only. Let me get social media hooked up here and we'll be ready to fly. Of course, if you're watching on the Polite Society podcast feeds, go ahead and comment on the live video. And if you're watching anywhere else, go to Twitter, tweet with the hashtag #TheBullet. And we'll get those comments. If they're relevant, we'll get them on the air. We'll discuss them live. And social media is all hooked up. Alex, we got two press releases from SAF that I want to, well, there were three, but two I want to discuss with you that I want to talk about today. First one, Second Amendment has filed a motion to intervene in a federal lawsuit challenging the federal government's new regulatory definition of a firearm, including the frame or receiver. The case is known as Vanderstock et al. Versus Garland et al., and was filed in the U.S. District Court for the Northern District of Texas, Fort Worth Division. A company known as Blackhawk Manufacturing Group has already been allowed to intervene as a plaintiff. Joining SAF is Defense Distributed, a Texas-based company. I'm going to jump down a bit because I think we can easily paraphrase a lot of this. And there was already a decision you and I talked about in terms of Blackhawk Manufacturing. I believe they got a temporary restraining order in this already. What is the a motion to intervene? Is this asking to join in? What does a motion to intervene do?
Yeah, so basically what an intervention motion does is it allows a party to intervene, to join in a case, basically under the premise that the case can't be resolved without their involvement, because they, or in this case the Second Amendment Foundation's members, have an interest in the case, the outcome of the case, and that they may suffer some harm if they're not allowed to be a part of the case. So here the Second Amendment Foundation has filed a motion to intervene so that then they can become part of the case to protect the interests of their members.
Okay. All right. So, and the case basically is around Defense Distributed and I believe that they call it the Ghost Gunner. It's basically, it turns a block of aluminum into a AR lower. Into an AR-15 lower. And the ATF has ruled that is not allowed. And in the history of the United States, they've never said an individual cannot make their own firearms. The ATF, and they've never been outlawed by Congress. The ATF seems to be making this up on their own, which is why the SAF is stepping in, is my understanding.
Yes, and there's a few things going on here, as you point out, Paul. Number one is that there's this constitutional violation happening because they're saying that basically that manufacturing a firearm from a block of aluminum is unlawful. And I think that violates the Second Amendment, especially in light of the Bruin decision. But then there's also this separate issue about the separation of powers. And this just goes back to basic civics 101. We have the judicial branch, the legislative branch, and the executive branch. And the ATF is part of the Department of Justice, which is part of the executive branch. And what the ATF is doing here is basically acting as a legislature by redefining terms contained in legislation. And the ATF, I think, is clearly acting beyond their authority by doing this, by engaging in this rulemaking. Now, Congress has given administrative agencies some rulemaking authority, but not with respect to what's called major questions, and that means the definitions of essential components of legislation, like in this case, the definition of a firearm. Mm-hmm. I think the complaint filed by the SAF, I read through part of it, and it talks about how Congress gave the word firearm a definition in the Gun Control Act of 1968, and Congress never defined firearm to mean a frame or a receiver, or that was never part of the definition of a firearm. So if you go back to the legislative definition, we don't have anything that includes a frame or receiver. But it's in 1978 that the first time the frame or receiver was included in the definition of a firearm, but that wasn't made by Congress. That was made by an agency regulation. So I think even then that was likely unconstitutional and a violation of the separation of powers, because this agency rulemaking was stepping on the authority of the legislature. So I think that's the other component here. There's the constitutional component, and then there's also the separation of powers component.
And I think that second one is going to be as powerful, if maybe not a little more powerful, than the first. It will, if it comes out our way, and I have no reason to believe it won't, it will really rein in the ATF and to some extent the FBI.
Right. The one thing I want to point out too is that in 1978, when they defined a firearm to include a frame or receiver, the rule back then said that items such as receiver blanks, castings, or machined bodies in which the fire control cavity area is completely solid and unmachined have not reached the stage of manufacture which would result in the classification of a firearm according to the Gun Control Act. So that's the definition that companies like those who make 80% lowers have operated under since 1978. And the ATF is trying to change that definition to include basically blocks of aluminum that still require significant machining and finishing to make it a functional receiver.
Yeah. The second press release today, Second Amendment Foundation, and this is a big one as well. Second Amendment Foundation has won a preliminary injunction against the enforcement of a New York State ban on firearms in places of worship, with U.S. District Court Judge John L. Sinatra Jr. declaring plaintiffs' constitutional rights are being violated. Quote from Alan Gottlieb, "We are satisfied with the speed shown by the court in this matter. It shows the court is taking this case very seriously." Jumping down a little bit, in his 44-page ruling, Judge Sinatra noted New York's new place of worship restriction is unconstitutional. The state has not demonstrated that the prohibition under its newly enacted law, adopted in reaction to the Supreme Court ruling in the Bruin case, that the ban is consistent with its nation's historical tradition of sufficiently analogous regulations. The state's exclusion is instead inconsistent with the nation's historical traditions, impermissibly infringing on the right to keep and bear arms in public for self-defense. Judge Sinatra wrote. I want to add a little bit of context in here, and this is very prescient, very, very timely, in that I read a story last night as I was getting ready for bed. FBI yesterday put out a warning to synagogues in New Jersey, not New York, but right across the border, that there are credible threats against synagogues in that area. And boy, I'm telling you, if there's some place I think you should not be forcibly disarmed, it's at a place of worship.
Yeah, and in fact, as the brief with respect to the preliminary injunction points out, at the founding era, many churches required their attendees to carry a firearm because they were expected to protect the place of worship and the other members of the church. So I agree with you. I think that if there's any place where you should be allowed to protect yourself and your fellow congregants, it would be at a place of worship.
Absolutely.
One thing I'd like to point out, Paul, if it's okay, is that
sure.
We've talked about in past shows about a temporary restraining order versus a preliminary injunction, and they basically are the same thing, except that a temporary restraining order is something that's typically given out more quickly because the harm is likely to be that's suffered without a temporary restraining order is likely to be significant, and it's likely to happen soon. Whereas a preliminary injunction operates to prevent the state, in this case, from enforcing their law, but it's during the entire pendency of the case until it can be fully litigated. But in either case, the judge will only grant a temporary restraining order or a preliminary injunction if the person or the party asking for the restraining order or injunction shows that they're likely to prevail on the merits, they're going to suffer irreparable harm, and it serves the interest of the community. And here the judge said that the Second Amendment Foundation and the plaintiff had met that burden and issued the preliminary injunction. So that's a good sign. It obviously keeps the state from enforcing this unconstitutional measure, and hopefully, when the case is fully litigated, we have a favorable outcome, and I think we will. Go ahead.
And I want to go back to that, in that the judge thinks there's a likelihood that the plaintiffs are going to prevail. Now, that's not a certainty, and of course we've still got to go through the process, but this is, if I were a betting man, I would not be uncomfortable betting the mortgage that at least part of this New York law is going to go down in this lawsuit.
Yes, I agree. I think it's likely that it will. Again, I'm like you, I'm not a betting man, but I think there's a substantial likelihood that the plaintiffs will prevail here. The other thing that's interesting in reading SAF's brief is that it sounds like the state basically made the same arguments when they opposed the temporary restraining order, when they opposed the preliminary injunction as when they opposed the temporary restraining order. And their argument stems around this perceived dispute about what period of history we should look to when evaluating Second Amendment analogs or restrictions on Second Amendment,
right.
The Second Amendment right. And they argue continuously that we should look to Reconstruction era, so laws that took effect after the Civil War, when I think clearly the preferred time period is the founding era, the time when the Second Amendment was adopted. And that sort of stems from this idea that we should look to the original meaning of the Constitution and the constitutional amendments. And we should look to the meaning of those, the textual meaning, but also the understanding of the people who drafted the Constitution and those amendments. And I think looking beyond that is just inappropriate. And I think the judge here agreed with SAF that the founding era history is the history that we should look to.
Well, and one thing I love about the Bruin decision and that text, history, and tradition doctrine is that we often hear the Constitution is a living, breathing document, and that's just not the case. The Constitution is the Constitution. It's words that are written do not change unless amended, and we've got several amendments to the Constitution. I believe there's 21, but don't quote me on that. And with the Bruin decision and having to go back to the text, history, and tradition, and pointing at 1791 when the Second Amendment was brought into the Constitution and the initial 10 amendments to the Constitution were adopted, brings us back to the Constitution means what it says. It really takes away this is a living, breathing document.
Yeah, I think you got to think about when the context when the Bill of Rights was adopted and when the Constitution was adopted. It was drafted and adopted after we'd won independence from Great Britain, and it was put in place as a document to restrain government.
Yep.
And initially, the Bill of Rights was the first 10 amendments, which we refer to as the Bill of Rights, was meant only to apply to federal government action, but it was meant as a restraint on the government. And it didn't give the government authority. And in fact, the Federalists, when you look at the Federalist and Anti-Federalist debates, the Federalists didn't think that we really needed the Bill of Rights because they said, look, the Constitution says that the powers of the government are few and they're explicitly stated in the Constitution. We've only given it certain limited powers. Why do we need to adopt these restrictions? And the Anti-Federalists, thankfully, insisted on the adoption of the Bill of Rights because they said we don't trust a central government not to devolve into tyranny. And so we want these 10 amendments in place as a restraint on government, as a restraint that they won't go beyond those certain limited powers and they won't infringe on these rights that we think are essential to a free citizenry.
Absolutely.
So if the current population wants to change that, like you said, they can amend it. They can get rid of the Second Amendment if there are enough people who want to do that.
Well, and
but there are
is
protections in
the 18th and 21st Amendment. The 18th Amendment banned alcohol throughout the United States. The manufacture, sale, and consumption of alcohol were banned in the 18th Amendment. And the 21st Amendment repealed the 18th Amendment. So there is a precedent of getting rid of constitutional amendments, and it happened within the last 100 years.
Right. So if the days we live in today are such that the population doesn't believe that we need certain amendments, well, convince enough congressmen to amend it or repeal certain amendments and
To commit
make it happen.
career suicide, yeah.
Exactly. Exactly.
I'm gonna jump off to one story I did not get in show notes, but we discussed briefly in when we were talking pre-show. There's a story that came out this week that an Obama appointee took Justice Thomas to task and said, "Look, I'm not a historian. How am I supposed to know what was law in 1791?" Mike Piwowarski and I talked about this yesterday, and even after my stroke and my challenges reading and my challenges writing, I do know there are these things called books, and now we even have this beautiful thing called the internet, where you can look up references that do go back even farther than 1791. And judges, especially when you get to federal judge, don't they have a staff of people that can do, oh, I don't know, legal research for them?
Yeah, they typically have a pretty educated staff with lots of resources, basically unlimited resources in terms of research. And then furthermore, the parties get to brief the judges on where they should look. So each side gets to make submissions about what periods of history the judge should look to. So the judge is going to be flush with historical record by the time that the decision comes before the judge. So I've made that comment too, that I'm not a historian, but when I say it, I mean I can't just rattle off a bunch of facts off the top of my head. Right. But we live in a day and age, like we were talking about earlier, where each of us has an incomprehensible amount of information at our fingertips at any given time. And there's just so much information that we have, and a historical record that we can look to, whether it's, and a lot of it's free. You don't have to look necessarily to resources that are behind a paywall. Google Scholar has an incredible amount of information, both legal resources and historical resources, and that's just one example. So to say that judges aren't historians, I think is just a cop-out.
Sure. Very much like how am I, and I equated this yesterday, how am I supposed to know the difference between a man and a woman? I'm not a biologist. That's what I heard when I read that. Get a comment in here real quick. Roderick says, NYS RPA versus Bruin is the gift that will keep on giving. Yeah, it absolutely is.
Yeah, I think that's a great point, in that Heller in 2008 and McDonald in 2010 were important and momentous decisions, but I don't think either of them was quite as strong as Bruin in terms of the effect that they will have on the future. And I think Bruin, because of the composition of the court, was a stronger decision for Second Amendment rights, for individual rights, than Heller and McDonald. Because remember, when Heller and McDonald were decided, the court was it was a close 5-4 decision in those cases. Mm-hmm. And so I think some of the more conservative justices like Scalia and Thomas had to compromise and join an opinion that wasn't quite as strong as they may have given otherwise. But since that time, with the addition of Gorsuch and Amy Coney Barrett and Justice Kavanaugh, I think that the court in Bruin was able to come up with a much stronger decision than Heller or McDonald in terms of the effect that it will have going forward.
I want to branch off just a little bit, because we're less than a week. On Tuesday is Election Day. And I want to remind everybody what happened just about 4 years ago. Just about 8 years ago, when we were coming to the end of Obama's term. And a Supreme Court justice, and I'm trying to remember and I just cannot, when was it Scalia that passed? And they let that seat sit open for 2 years, the Senate did. Rather than give Obama an appointee, they said, let's see who wins the election. And of course, Trump won the election. That's what led up to Bruin. This coming Tuesday is incredibly important. If we can get 3 to 4 seats in the Senate and we turn the House solidly red, we could be in a position where we could hold the court, and we could possibly give the next president a chance to expand that 6-3 and maybe make the next decision a 7-2 decision.
Yeah, that's a great point, Paul. I believe the circumstance you're referring to is actually when Merrick Garland was nominated
And did not
to
get the
fill,
seat.
and did not get the seat. And of course, he's now been in the news for lots of other reasons, as we've seen post Bruin. So he's still got into a position where he could use his anti-gun ideology to bad effect, but at least he's not on Supreme Court.
Yes. Could you imagine the damage he could have done on the Supreme Court? Wow. Well, we've got about 4 minutes left, and I want to cover this last story a little. We're not going to have the time to give it what it deserves, but I got this off the Dayton Daily News today, pulling up the story here. After a year in jail, a Dayton man found not guilty in death of 61-year-old. Basically, two men got into a confrontation, and there was the physical part to this confrontation, and one man died as a result of a stabbing. And I want to get to this quote out of the story. Prosecutors said a new Ohio law played a role in the outcome. Quote, when Senate Bill 175, the new law commonly known as Stand Your Ground Law, was passed, there were many criminal justice experts around the state who predicted that the new legislation would result in more defendants being acquitted, such as this, especially when the only living witness is the defendant, said Prosecutor Ann Gramza. The police and prosecutors are seeing a significant increase in self-defense claims under this new law. I'm going to go ahead and I'm going to grab the link to the story, and I'll put it in the comments for both YouTube and Facebook. But Alex, this story, and in reading the story earlier, when the police got to the scene, the person who spent a year in jail and was tried for murder was giving first aid and was trying to save the life of the person who died. That's not generally something you see in somebody who is intentionally committing murder.
That doesn't show consciousness of guilt necessarily. And I think the other interesting part about the quote that you read, it says that, and this is the prosecutors again saying this, they say that there were many criminal justice experts around the state who predicted that the new legislation would result in more defendants being acquitted. It doesn't say innocent people going free or guilty people going free. It says defendants being acquitted, as if that's a bad thing.
Right.
Well, what if all these defendants being acquitted are innocent? And all it means is that the state is not able to disprove beyond a reasonable doubt that these people acted in self-defense. So if they can't make their case, then of course they're going to be acquitted. And the prosecutors are posing this as if this is a terrible thing. And that's exactly what our criminal justice system was developed to do, was to hold the state to their burden and to make sure that only guilty people were found guilty.
And my issue here is there is a 31-year-old man who was just acquitted. He was found not guilty. He spent a year in jail. That's a year of his life lost. The state is not going to compensate him, although I believe they should. He's suffered significantly, and what's he going to get? The state saying, "Oops, our bad." No, I don't even think they'll do that. They'll just say, "Okay, you're free. Go get out of our face." That's what he's going to get.
Yeah. It's really awful. He lost a year of his life, and he'll have no recourse for it. He will have spent a year in jail, and sadly, I'm familiar with a case here in Indiana where a gentleman was found not guilty. He'd spent a significant amount of time in jail. Eventually, he was able to bond out. And after the not guilty verdict, the judge still took his bond to pay for court costs and fees after a not guilty verdict. So, yeah. So go through all this pain and suffering, get an acquittal, a not guilty verdict, and then still have to pay court costs and fees out of your bond money. It's just, I thought that was pretty awful.
I would absolutely agree with that. That's, the prosecution side has way too much, and they misuse the power they have, thinking about New York, and we're gonna do away with bail. We're just gonna do away with. We're just gonna, unless you've actually killed somebody, you're gonna get out the same day. Yeah, no. Whatever happened to protecting the public and serving the public? Anyway, we're out of time. Alex, I'm sorry. We always end up doing this, but on our way out the door, man, anything you want to plug?
Yeah, just once again, I'm an attorney. I was wearing my attorney hat today. I'm going to be wearing my firearms instructor hat tomorrow. I'm doing a basic handgun course tomorrow. If you're interested in firearms training in Indiana, check out o2gungroup.com. And then obviously I practice law through ooleylaw.com. You can reach us through there. Check out what services we provide. We do criminal defense, firearms related issues, expungements, etc. So check us out at ooleylaw.com and o2gungroup.com.
And one thing I know you do that I think is interesting is if somebody has had their firearms rights taken away, one of the things you specialize in is helping them get them back.
That's right, and a lot of times that involves an expungement, or if there's been a domestic violence conviction or restoration of rights after a domestic violence determination. So that can be a complicated process to go through and an intimidating one. And frankly, there just aren't very many attorneys who are gun people and who are familiar with firearms and firearms law. So if that's something that you're interested in, we're happy to help with that.
Very cool. On my end, that's going to wrap up the Monday through Friday edition of the Bullet for this week. Tomorrow, we do have a Saturday Week in Review edition coming up at noon Central Time tomorrow. Please do come join us for that. Until then, everybody, thanks for watching. Thanks for commenting. Please like and share the videos.